All right. Hello, everyone. Welcome to the latest monthly installment of the virtual EFF Austin meetup. My name is Kevin Welch. I am the current president of the board at EFF Austin. We also have two other board members with us tonight, Ritika Gopal, who is giving our presentation tonight, and John Lebkowski, who is also the former president of the board. So for those of you who are first timers or don't know who we are or what we're about, so EFF Austin is short for Electronic Frontier Foundation Austin. We are a Austin-based digital civil liberties organization who's been around going on almost 30 years now. In fact, hopefully COVID times will end in time for us to properly celebrate our 30th anniversary. But I've been around almost 30 years. We're an Austin-based digital civil liberty organization affiliated with Electronic Frontier Foundation, which is based in San Francisco, which is only a little older than we are. We are almost as old as them. We are, in fact, the oldest member of what is called the EFA, or the Electronic Frontier Alliance, which is a group of sort of non-hierarchical affiliate organizations all around the country, and in a few cases even around the world, who work in conjunction with EFF to fight for similar policy goals. EFF is essentially the nation's oldest and foremost digital civil liberties organization. You can think of them as the ACLU for the internet, which is both fairly accurate, but also doesn't really do full justice to their history and everything they do. But they fight on a diverse set of issues, including things like net neutrality and encryption, stopping the spread of government surveillance, protecting Section 230 of the CDA, and just in general trying to make sure that people's constitutional rights, specifically their First and Fourth Amendment rights, are protected in emerging technological spaces. So yeah, they're cool. You should donate your time and money to them if you have either of those things. And if you have a lot of time and money, we'd always welcome your help and donations as well. The main thing we tend to do, they focus very much on a national level, mostly doing legislative advocacy. We're much more on the state or even local level here in Texas and Austin. We are primarily an educational organization because as our former president John always likes to say, we could be described as an org that has always been short on money but long on talent. So we leverage our board, which is a group of very smart people with very diverse backgrounds, and we use it primarily to try to educate the public on digital civil liberties issues, which is the primary point of our ongoing monthly meetup series, which in the past has usually been at Capital Factory in downtown Austin, but for the time being is now online because of COVID, and will continue to be there for the time being because, hey, you know, it works pretty well, although I do miss the getting drinks with people afterwards portion. So this is the main thing we have going on for the time being. If you like tonight's presentation, want to watch more, as I said, second Tuesday of every month at 7 p.m. in this Zoom room. John, who's here with us tonight, John Lebkowski, is going to be giving November's meeting. He told me what he's going to be talking about, but I'd have to check my email to remember. But John is a brilliant thinker on all things futurism, so he will probably have some very interesting insights on the state of the world. If you're a fan of things like Bruce Sterling's State of the World addresses on the Well, John Lebkowski co-hosts those with Bruce. So John's musings tend to be not to be missed. We're also going to be in December hearing from UT's Professor Dr. Sharon Strover, who's probably going to be talking to us about her latest research on online disinformation campaigns. I'm sure she won't have anything interesting to tell us about that's been going on recently. So yeah, that should also be fun. Should check that one out. If you're interested in speaking at some point next year, get on the calendar. I'm currently actively looking for new people. Although I potentially may have just booked January, even tonight, with EFF Austin's friend Joey Lopez, who is a teacher at, I think he's at A&M now, but he's associated with the old ACT Lab program at UT, which was under Sandy Stone, which was basically the cyberpunk program at UT, as I like to call it. So Joey, I don't know what he'll be talking to us about yet, but I wouldn't miss that either. Finally, let's see, anything else major coming up that I want to share with you all that we're working on? Usually annually we have a holiday party. Obviously this year is weird. We're probably going to do the holiday party virtually in the Zoom room. We're still figuring out exactly what that will look like. It could just be as simple as nerds hanging out in a Zoom room, but we may get a little more involved as the board members' time and interest permit. I'm also currently exploring the potential possibility of finding safe, large outdoor spaces that potential socially distanced events slash fundraisers for EFF Austin could happen in. I've been having a few conversations with our friend Owen McNally, who might have a good candidate location for us. That's in the very early planning stages, and obviously we'd have to figure out how to do it in a way that would make sense and be fun and be safe. So that may happen at some point, but we're not going to move faster than makes sense to do the event right. I will keep everybody informed as that moves forward. Let's see. Oh, also, this coming next year, like starting in January, it is the Texas legislative session, which happens once every other year for 6 months. So now is a great time to pay attention to what your state legislators are doing when it comes to laws and bills being proposed. That 6 months is the best time period for you to actually have an impact on what becomes law here in Texas. We will be keeping our eyes on things in the digital civil liberty space as they become aware to us. And if there's actions we think any of you can take that will be helpful in this regard, we will, of course, let you know. Also, we continue to push as part of a lot of the conversations around reimagining the Austin Police Department. We are sponsoring an initiative in conjunction with EFF to encourage the Austin City Council to considering banning the use of facial recognition technology. We have a petition we've been gathering signatures on. I will post the link in the chat here. If that's something you feel passionate about, we encourage you to sign it, because the more signatures we get on that, the more likely we can actually get council to listen to us. So yeah, I think I've now almost gone over everything currently in our docket. I'm sure John and Rick can remind me if we're working on something that I've forgotten about. Oh, also a quick shout out to some stuff that John is working on. John is currently co-producing and hosting a I think it's still weekly podcast series with his Photopia News Network in conjunction with Scoop Sweeney, who is also here in the call tonight. So John just shared the link. Yeah, they have great guests on. They've had some of the EFF Austin board on. If you like EFF Austin, these sort of topics, and want more content, especially maybe with a little more of just a speculative futurist shooting the shit slant, but you should check it out. But they get really amazing speakers, so I encourage you to check that out. And now I guess final thing, he's not with us tonight, but our board member Dave, actually maybe David is here, I'm not sure, but our board member David is currently working on trying to put together an EFF Austin book club. If that is something that you would be interested in, you can, I guess, send me a message in the chat here, and I can work on getting you hooked up with David and getting involved in that. Before I finally now turn things over to Ritika, I'm I generally ask the community if there's any announcements anybody would like to make. Shameless self-promotion is totally allowed. As long as you think it is some event or something or some piece of information that is relevant and of interest to the EFF Austin community, feel free to share it. Does anybody have anything they'd like to share with the group before we get started? Yes, what John said in the chat. That's very important, and you should do that. And, I guess, EFF Austin, we are a nonpartisan organization, so we're not going to tell you who to vote for, especially because as anybody who follows privacy and digital civil liberties issues knows, it is actually a somewhat, one of the few sort of crossing the partisan divide issues left. You can find conservatives who are very good on these issues, and you can find liberals who are very bad on these issues. So we're not going to tell you who to vote for, but yeah, you should vote. Participating in your democracy is important. Cynicism is not cool. We're not about that here. So any community announcements before we get started, other than John's wonderful reminder? No? All right, well, in that case, I am going to turn things over to our speaker for the evening, Ritika. Ritika is a member of the EFF-Austin Board. She is also a local attorney specializing in the intersection of tech and transactional privacy and platform law. Ritika here is going to be giving us a talk sort of exploring where, you know, things like copyright law really stands in the face of the internet and the new sharing, remixing art forms that the internet has engendered, and whether the current laws really make sense given the realities of how the internet works and how creative expression works on the internet. And I don't want to speak for Ritika, but I believe she has also indicated as much that a lot of her interest in this might also stem from that she is a budding DJ, an art form that is entirely about remixing existing works. So I'm going to turn these over to Ritika here, and we're going to learn a little bit about how should creative expression and the law around it work in our new technological spaces. So take it away, Ritika.
Awesome. Thanks, Kevin. Okay, I'm just going to test this out really quick because I'm new to sharing PowerPoints with presenter views. So I'm just going to Kevin, if you can give me a thumbs up or something that tells me that you can see the next slide. Is that working?
Yeah, if you can see my thumb.
Right. Virtual thumbs up. Perfect. Okay. Awesome. Well, thanks everyone for, taking the time to get on yet another Zoom meeting. I know Zoom fatigue is real, so I doubly appreciate it. Just to reiterate, my name is Ritika Gopal. I'm also a board member of EFF and a local attorney here in Austin. As Kevin alluded to, I am a budding amateur DJ. I'd say heavy emphasis on the amateur bit. I will say that it's been a blast learning the basics, especially during quarantine, while all the dance floors have been gathering dust. And just, speaking of COVID, I guess that's why I've delved into this hobby, but also been heavily consuming, live sets through online live streams like YouTube and Twitch. And I'm sure that applies to all of you too. We've all turned to online platforms for entertainment, communication, and, frankly, human connection. But frankly, I'm tired of all the Zoom happy hours. I think that has to go. But anyway, that's basically the crux of tonight's talk, right? We're consuming online content more than ever. We can't go to the movies. We can't go to our favorite venues. And, we've kind of been using online platforms as a substitute for, that kind of entertainment and content and information. And so I'm here today to talk about, the area of law that underpins the sharing of that content and on those platforms. And so that's kind of what I want to dive into. In an age, that's defined by abundant creative expression that's been facilitated through the internet. My view is that copyright law and enforcement has largely failed to calibrate accordingly. To me, there's a growing rift between, and I might use this term throughout the presentation, what I call, well, I haven't coined it, but the term is copy norms. And that's basically societal norms as they relate to the use of copyrighted materials. So the growing rift between copy norms and copyright doctrine. And so my, ultimate question here is, how suited is the copyright regime in its current state? How suited is it to capture the myriad content that's shared online? And are certain mechanisms within copyright worth re-examining? I think it is, and so I think I'm going to go ahead and dive into it. Here we go. Awesome. Okay, so I'll just give you a quick roadmap. I'm going to try to zip through this. This PowerPoint is longer than I expected, so Kevin, please let me know if I'm like running over time or anything. But what I'm hoping to do is
I'll just say that unlike the physical meetings, we do not have any hard deadline of they boot us out of the room at 9. I can keep the room open as long as you want to talk and as long as there's still people listening. There's
Perfect.
There's no hard deadline.
Awesome. Yeah, I don't have a view of the gallery or anything or the chat. So if you have any questions, I'm going to say save it till the Q&A part. But if you have a burning question, go ahead and, just jump right in and unmute and, you can ask your question.
And I'll just second. I meant to say, yeah, everyone, it can get unwieldy having people all try to speak in a Zoom room. So ask questions in the chat and we should be able to get to all of them because we're not time limited unless you all ask hundreds of questions. So ask them in the chat.
Cool. Awesome. Okay. So let me just go through this real quick. I'm hoping to give a sort of brief overview of the changes the internet has brought to us and just, the current state of the technological realities we find ourselves in. Next, I'll go into like what's on the books, the basics and mechanisms in place in copyright law, and specifically how those pertain to digital collage art forms. And by collage art forms, I mean, the stuff that we're consuming every day. So, memes, remixes, music with samples, and the remixes can be unofficial, official, catchphrases, the Carlton dance. I mean, it's a wide range of art forms that are out there that we're consuming every day and also consuming news through memes. At least I am. I'm definitely finding myself doom scrolling through Twitter almost every night. So that's been really helpful for me. And then we're going to go into the assumptions, sort of grounding the analysis and any recommendations that come out of this presentation. And then after that, I will go into like examples of appropriative and recontextualizing art forms. I kind of touched on that 2 seconds ago. Give general overview of that, and then see how copyright applies to those art forms and to what extent it's successful. And then, of course, going into possible recommendations. And then afterwards, I'm hoping that there's time. I'm going to try again to zip through this. For there to be a lively discussion, Q&A. I don't know everyone's sort of familiarity with the topic, but happy to explain further during Q&A, or if people want to, talk with each other. That's how kind of the EFF meetings work too. During the Q&A, it's not just, one, I guess, speaker and audience. It's kind of a group discussion. So, to the extent that Zoom can allow for that, I'd love for that to happen. And then lastly, if there's time, and I think I'm hoping that there's time, I'm going to do a mini set with 6 songs. So it's like about, I'd say roughly 20 to 30 minutes. And just to kind of, for educational purposes, the only issue is that the tech might be iffy. So I'm hoping that it's all worked out, but I'm really excited. Okay.
I am as well. It might almost, and actually probably be better than the bar outings. So yeah, thank you for giving us a chance to pretend that we are in meat space together.
Right. It's like a halfway point, I guess. It's name of the game, I guess. Anyway, so.
Where did you find my childhood, Ritika? What is all this?
I was going to ask, do any of these look familiar? I'm sure to many of you, you spend a lot of time on these platforms, and I'm just trying to showcase kind of sort of the early days of the internet is a relative term, but for me, some of these brands played a huge role in my formative years. I won't say which, but I mean, who are we kidding? I downloaded 1,000 viruses from LimeWire, but I got to access music and content. I was a teenager. It's fine. But things like Tumblr, MySpace, Zanga, you got to share images and music, and I think that was sort of the initial start of this. The budding sphere of like social media, and of course now it looks very different today, and I'll go into that. But the rise and development of the internet and this kind of ecosystem of file sharing platforms has has really, precipitated an abundance in creative expression. So much so that, I think people will agree with me that it's significantly altered, communication and how we share information. I mean, I can just like send you something, I don't have to mail anything to you, and we're not in a dial-up version of the internet, so it's just seamless communication. And so with that, I think there's an impact on what Professor Lawrence Solom calls copy futures. They alternate copy futures shimmer on the horizon. So we're going to see how the development of internet technologies, the internet, and then communication technologies and platforms can really affect how we protect art, but also are able to share it via copyright. So just a little overview of today's technological landscape. The digital revolution has recast, the system of free expression in a completely new light. It has enabled widespread cultural participation and interaction that previously couldn't exist on the same scale. I can watch, I can stream a Studio Ghibli film almost instantaneously. These technologies like peer-to-peer file sharing systems, the MP3 file format, just general social media networks that rely on user-generated content, that has dramatically lowered the cost of copying and distributing content. So, you can easily download, an image and then add a cheeky caption and turn it into a meme. And, maybe it goes viral, and I'm hoping that happens to me one day, because that'll be my legacy. But there's no need for, CDs or tapes. I mean, you can instantly download music, especially with the introduction of the MP3 file format that really changed the game. And I'm, harking back to the Groove Shark, LimeWire type of existence, where it was just so new to be able to like look up music in a music library of some sort. At least that's how Groove Shark was, if I remember correctly. And then LimeWire, of course, was just like a repository of all the copyrighted content in the world that I could download. Not saying that that's good. Definitely not saying that's good. That was illegal. But I think it just goes to show how copying and transmitting information and distributing content is just so it's very easy. And so
I think I'd just say, Ritika, it's probably going to be easier to find the people who haven't illegally downloaded stuff in this room than the people who have. So you're in good company.
Yeah. And, I don't know if my parents are on, but I've definitely slowed down many of their old laptops due to my downloading behavior. So sorry. Anyway, so because it's easier for, to share content and everything, as an individual user, you're able to innovate so much with existing content. You can comment upon it, build upon it, and, in aggregate, like people can, with relative ease, like I said, download, combine, mix content with other existing content, oftentimes copyrighted content, to produce something that's entirely new as a means of expressing themselves to the world and engaging in, meaning making in this like cultural space, like information cultural space. So, that's really, I think, key here. And so what has happened is that there are, these contemporary appropriative art forms pose a bit of a special free speech problem. To quote Professor Jack Balkin, who is, a prolific writer in this field, he's amazing. He basically talks about how the creative and opportunistic use of trademarks, cultural icons, and bits of media to create, innovate, re-edit, alter, etc., forming pastiches and collages are basically turning into the standard technique of speech and expression. And like I said, it's not clear right now, and I'll go into this in a second, whether these critical modes of communication are protected under the copyright regime, which, espouses a much more traditional interpretation of originality. But regardless of that, the good news is that speech and expression has been democratized because of these technologies, and the means of transmitting that expression has been put in the hands of an increasing number of people, and an increasingly diverse segments of society. So that's really cool. I think the overarching theme here is that in the digital age, distribution and innovation go hand in hand. So just, kind of keep that in mind as a backdrop to what we're going to talk about next. All right, now do these look familiar? So these brands or platforms are the reality we currently live in. I might be a little more mainstream. There might be others that I'm not aware of, but during COVID, especially while we try to stay safe in our homes, we spend many of our waking hours on these platforms. I mean, I get that notification on my phone telling me how many hours or percent of whatever time I've spent on the phone has been spent on Instagram. It's not fun to see that time. But in any case, the reality is that we are on these platforms, and like I said, these emerging communications technologies and platforms have given life to new modes of critical and cultural expression. And some of that is, again, those collage and appropriative art forms. And, with these platforms, they just propagate, cheaply and quickly and in a viral sense. So like I said, that applies fully in the realm of music. You've got people live streaming their DJ mixes or DJ sets, or uploading their mixes that they pre-recorded. There's also memes, like I said, the recontextualizing the stock photos. I'm thinking about the jealous girlfriend meme that's made its way around the internet. That's a funny one. And yeah, it's like helpful to think about, how much these forms of expression permeate through our lives, and how much we use those to communicate with each other. So I think that's something worth noting as we kind of talk about the law, which will be next. And so let's see. Sorry, 1 second. Okay. Lastly, even if the previous logos that I shared are, new to you or less familiar, I'm sure you are familiar with this logo, or sorry, this symbol, not logo. The copyright. What is a copyright? I don't know the level of familiarity, of the audience, but I'm just going to go through the basics real quick. Copyright is the driving force of, the dissemination of content, the cultural dissemination of art. And it's important to note that intellectual property is quite different than, real property. So what we mean by real property is something that you can touch, feel, and you see the, real property right, see it, Whereas intellectual property, with IP, you can touch, feel, see the physical object within which the right is embodied. So just for an example, say you buy a Coldplay CD because perhaps you're feeling nostalgic for a time that Coldplay was a good band. The CD itself is not the copyright. It's just an object. Coldplay's musical composition and their recordings, that's the copyright that is in the object of the CD. So those are subject to copyright protection, and those are embedded in, and that copyright protection is embodied in the object. And so at its core, copyright furthers the idea that ownership of a work is conferred onto the creator, and that exclusive ownership functions to protect an artist's creation from unauthorized copying, a la LimeWire, let's say, and unauthorized copying and use by others. So copyright protection is available for, and this is really basic elements, right? Original works of authorship fixed in any tangible medium of expression. So works of authorship, and this is also stipulated in the statute itself in the Copyright Act. It includes musical works, dramatic works, choreographic works, sound recordings, and much more. And then what is like creating a work, basically the constitutional minimum is that it needs to be an independent creation with with a modicum of creativity. So these are basically the two aspects of a copyright, like how it forms. There's no need for registering a work for copyright protection. It automatically applies once the original work is fixed. So that's just good to know when you see a C there. It doesn't necessarily have to be registered with the Copyright Office. That is the trademarks, a completely different story and outside the scope of this discussion, but good knowing, worth knowing. Okay, so, what are the sources of, what are the sources of law for copyright? There's two main ones. Copyright law draws its persuasive thrust from the copyright and patent clause of the Constitution. We all know what the Constitution is, I hope. It states that, Congress is empowered to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So I read this verbatim because it's important. Already this clause kind of talks about the goal of copyright. That's to promote the progress of science and useful arts. Yes, exclusivity is part of it, but it is limited by the phrasing limited time. So we know that this copyright protection is not perpetual. There's a term to it. And that's important. So, there's kind of a balance between freedom of expression, which I'll get into, and also access to works by the public, but also protecting, the artist's creation. And so, it's, again, important because it lays out the constitutional justification for intellectual property protection. And the idea is that, copyright protection is meant to strike an almost like utilitarian balance between providing incentives to the creative industries to invest in cultural production on the one hand, right? But then also encouraging access and use of those works by the public on the other. And so my leaning is towards the latter, right? Because I like that information and is accessible. I like free knowledge principles. So these two concepts are kind of on a balance beam, and it's really dependent on where you place the fulcrum, right? To have that like balance and harmony between the two. But I'll get into that in a few minutes. Secondly, the Copyright Act of 1976 is kind of where the body of copyright law is housed. So the Constitution is kind of like framing overarching thing, and then the federal law brings that purpose to light through legislation and black letter law. Oh, and I forgot to do those animations, but I think you get the gist. Okay, so what is copyright exclusivity? Like I said, under copyright law, a creator of an original work is provided certain exclusive rights. There are 6. And when you make, let's say I made a song is a bad example. Let's say I make I paint something. I have 6 exclusive rights that immediately come out or that are immediately available to me once the original work is fixed. So it immediately applies basically. But these rights are, one, to be able to reproduce the work. That's pretty simple. The second one is to prepare derivative works and compilations and collective works. So derivative works is the derivative work right is a really important counterbalance to what I'm going to talk about later. But that's really important to know, I would say, derivative work can include, I believe the definition includes wordage like, work that's based upon one or more pre-existing works, translation, musical arrangement, fictionalization, motion picture version of the original work, annotations, things like that. So that kind of butts head with what I'll talk about later, the fair use doctrine. And that's, endlessly fascinating area of where copyright and, free First Amendment law intersect. But, I'll talk about that in the context of music. But notably, there is no statutory exclusion for sampling. So, producers are probably struggling with this all the time. So, that's just the reality. The third right is, the ability to distribute copies or phono records of the copyrighted work to the public, by sale or their transfer. The next right is kind of important, the right to perform in public. So, in the case, this right specifically refers to, literary and musical works and compositions, not sound recordings. And it's pretty wild, but there's a difference between a musical composition and a sound recording. And it's kind of a very confusing setup. But anyway.
Well, I'm correct that that's how you can have it, where there is no copyright on the works of Beethoven, but there can be a copyright on a particular version of recording of a Beethoven work.
Exactly. To the extent that what the Copyright Act says about publicly performing is that, it's a public performance if you do it in a place open to the public, or in any place where there's a substantial number of people, and this is important, outside the normal circle of your family and its social acquaintance, so like close, family and like friends, and who knows what they mean by friends. I'm guessing like close family friends. But here's kind of a hypothetical, right? Like let's say you're best friends with Tony Romo or something, and as a favor, you offer up your, cover band to play at his reception. Family, like, close friends, close family friend. But, this is a Tony Romo's reception. So, it's highly public, and is it still within the ambit of friends and family? I don't know. It's kind of it's kind of really interesting to see like where you draw the line, like what's public and what's not. And I think the live streaming piece of it really blurs that line, where venues are, I guess venues have to get the ASCAP license, but it's just, I think the public versus private spheres are really evolving, especially during these times where we're inside for most of the day. But that's kind of why public performance licenses are so important. They're all the venues have to get the appropriate licenses, and I'm told that like the ASCAP and BMIs of the world are really good at figuring out which venues aren't complying. So super interesting stuff. The next right is, of course, the right to display the work in public, and then lastly, importantly, is that, in the case of a sound recording, what I was talking about earlier, you have the right to perform the copyright work publicly by means of what's called a digital audio transmission. And what that means is, the internet, so over the internet, so if you're live streaming on the internet, satellite, like XM radio and cable radio. So it's like Time Warner's musical channels. Awesome. Okay. So on the flip side, so you've got copyright on one end, right? Like what I just described, where it's protecting a creator's work. On the other side, you've got the Constitution again, right? Talking about free speech, freedom of expression. And that's a individual fundamental right. If any of y'all in the audience went to law school, you know that fundamental rights are kind of they're the bedrock of con law. And so, in the most basic terms, I think it's super interesting is that, the First Amendment, freedom of expression, freedom of speech, protects expression while copyright, regulates it. And, in my research, I've come across a lot of scholars that have, painted it either way, whatever which way. But one quote I found interesting is, legal scholar Paul Goldstein puts it as like, almost like a perpetual tension. So copyright persists in the potential for conflict with the First Amendment. But, I would just also recall that, and this might be getting too like legal-esque, but I'll try to, zoom out a second. But just recall that, in the copyright clause, there's, limited duration of copyright protection, and that's kind of meant to protect freedom of expression. And so because the Constitution includes both the copyright clause and the free speech clause, you can assume that there are like a certain range of sort of like higher order conditions that allow copyright and the First Amendment to actually further the same democratic goal, which to me is, not to me, sorry, like, which is, safeguarding the free and widespread dissemination of expression and ideas. And so the limited times piece and the freedom of speech phrasing, and in both of the clauses here on the slide, they work together in concert to find that balance. But that where, like I said, where you place that balance has to reflect, the backdrop of the technological, realities that we're surrounded by. So again, because our, modes of expression and speech and art forms have changed so much, I think it's worth figuring out, like, where does the balance lie? As for now, the Supreme Court has so far consistently rejected any notion that copyright and the First Amendment are in tension, or are incompatible in any form. So that's kind of, that's the state now. So, there hasn't really been anything definitive on that end, but, I'm just arguing that the technological changes have brought these two out of sync. So, again, parts of copyright law are worth examining to bring that back into harmony. Okay, so there are, I'd say the starting point of reform is to explore ways in which, we can reunify copyright and free speech, and so that they're, indeed working towards their shared goal. This requires, again, examining where they intersect. And so within copyright law, there are a couple of mechanisms that limit the scope of copyright exclusivity. Of course, not all of these mechanisms are created equal in terms of their amenability for reform. So, for example, the idea expression distinction, that's basically the idea that, like, copyright protection doesn't expand to an idea or procedure or discovery, like those are facts. But what it does cover is the expression of the idea. So, like, take, for example, the idea of a man, like, venturing out on a quest or a journey to, whatever, save the village. That can't be copyrighted, right? Because that's sort of a trope, or, like, character archetypes that can't really be copyrighted. But then the more specific the plot actually gets, so you have, like, unique plot points where, let's say, okay, now it's not just an idea, the idea of a man venturing out on a quest, but it's like Lord of the Rings. That's where it gets to be, original. And so the line between that is kind of is like endlessly fuzzy. So it's not really the best avenue to drive reform, I think. The first sale doctrine, it's not really applicable as much to digital works, and I'll tell you why. So basically, this doctrine gives the owners of copyrighted works, the right to sell, lend, or share their copies, right? Without having to obtain permission or pay fees. So if you buy a book, you can sell it to half price. Or if you have, like, old vinyl lying around, you can go to your local record store and sell it to them. You can break. You bought a CD, you can break it. Like, you can do that stuff with it. What you can't do is, like, make copies of it. So there was a case called Capitol Records versus Redigi, and the court said there that the first sale doctrine doesn't apply to digital works. So, clarified that resales of digital music files, like MP3s, are not permitted under this doctrine. So if I bought an MP3, I couldn't just sell it to you, because in effect, selling it to you just like makes a copy, which is different from if I just sold you a physical CD. And then of course, you've got the, limited term of a copyright. So when a copyright expires, that work falls into the public domain, and then, you're free to do whatever you want with it. Which is great. That I love that concept. But Congress has a long history of passing legislation that that's extended the duration of the term of a copyright. So I think in the last 40 years or so, and who knows if this is outdated information, but Congress has extended the terms of existing copyright 11 times, and twice for the term of future copyrights. So, despite the limited times verbiage in the copyright clause, there are pieces of legislation that are, working against that. And, one of these pieces is actually derisively called the Mickey Mouse Act. So, it's really a lot of it has to do with Disney lobbying to protect its copyright over its IP. So,
do you want the Disney family to starve, Ritika? Do you want them to starve? Or Sonny Bono? What did Sonny Bono do?
What will Sonny Bono do? Yeah, I'll just leave that alone. So there's a way to, I would say, yes, we should shorten the copyright term, but like that's never going to happen. So it's not very promising area for improvement.
Out of curiosity, Ritika, do you think the fact that copyright has started entering the public domain again, finally, after the 20-year pause, do you think as we get closer and closer to the date of Mickey Mouse entering the public domain, we're going to see more Disney lobbying shenanigans?
I wouldn't be surprised. They're very active on the.
I think it's only another 6 or 7 years before he will enter the public domain.
I mean, the issue is, though, that a lot of their IP will actually be preserved through their trademark rights over it, because it's a source identifier. So, I don't know to what extent they're how much they'll suffer by losing the copyright, but I doubt, they're going to lobby as much as they want. So, yeah, I don't think it's something that's going to change drastically. I absolutely doubt that the copyright term will be shortened, and right now it's pretty long. So it's not really a viable way to try to make art by just waiting for things to fall into public domain. Lastly, is the fair use doctrine, and it's kind of like the focus of tonight's talk. It's basically, in my mind, the most malleable and promising avenue to realign copyright with the freedom of expression. And I'll kind of go into what fair use is. So it's a it's a typical legal doctrine. It promotes, again, the freedom of expression by interestingly permitting unlicensed use of copyright protected works in certain circumstances. So this is in section 107 of the Copyright Act, but it basically provides a framework for determining whether a secondary use of a copyrighted material, if that is worth actually considering as a copyright infringement. So, the types of uses that are traditionally considered fair use is criticism, or commenting on a piece, or news reporting, teaching, things like that, where it's beneficial for society to be able to make reference to certain copyrighted materials. And so there are 4 factors in which courts view, each use in question and then make a determination. It's a case-by-case inquiry. It's very fact-specific. And, interestingly enough, the burden of proof in a fair use determination is on the person alleging that their use of the copyrighted material is fair use. And I'll make note of this later, but that's quite different from burden of proof in a, let's say a defamation case. It's on the person who, is allegedly defamed to prove that they were defamed. But anyway, so these factors are really interesting. I'd say the first factor especially is particularly important because it generates, it basically accounts for a larger portion of the judicial imagination relative to the other 3 factors. The concept of transformative came from the sort of preeminent Supreme Court case on fair use called Campbell versus EFF-Rose. And I'll kind of go into what that case was, but basically it held that that transformative uses, uses that add new material in a way that reflects critically on a original copyrighted work are favored and assumed to be less likely to damage the copyright owner's market interests. And so, basically those kind of uses, transformative uses, are considered objectively valuable to culture and society at large, and therefore in the eyes of law and policy are prioritized over one's copyright interest in the original work. And so you can see why fair use, particularly the first factor, I think is considered an interesting free speech mechanism to counterbalance the copyright exclusivity. But then on the other hand, if you look at, again, just refresh on what the exclusive rights are under copyright, you'll see that what's the difference, right, between a derivative work of a copyrighted work, or the difference between that and like a transformative work. The line gets really blurry, and I think I'll kind of give a little survey of the jurisprudence on that line. It's all over the place. It's the derivative work right is really difficult to reconcile with a transformation friendly fair use calculus, but I think it's possible. But we'll see. So, as I mentioned before, right, like modern culture is characterized by interactivity and mass participation online. And so, again, people are distributing, circulating, exchanging bits of culture. And so it's, it really exacerbates this problem between, what's considered derivative and within the scope of your copyright exclusive rights versus, what's fair use. And, society is benefited from being exposed to it. So anyway, that's why I'm analyzing all of this through the lens of appropriative art, because it really shines light on these key tension points. Okay, I think this will be the last of the sort of legalese philosophical stuff before we can get into the fun part. Yeah, so the grounding assumptions here that are driving that's driving the analysis is that the proliferation of digital technologies has unlocked new spaces for critical expression. I think I've said this 1,000 times by now, but that really applies to contemporary collage and appropriation art forms. So this we all know. I really like the idea of, if you guys are familiar with, John Stuart Mill. His theory of speech was based on the idea that free speech is a necessary means towards fostering a robust, diverse marketplace of ideas. So my assumption is that having a sort of marketplace of ideas that's has an array of choices where I can inform my worldview, but in a meaningful way, is a good thing. So regardless of the truth of, regardless of whether a dissenting concern is valid or not, I think the idea is that the exposure to all ideas aids in this societal search for truth. And so if certain types of speech or expression are banned or sort of, countered, I guess, by certain mechanisms, and people won't be able to benefit from that silenced opinion or art form that might have an ounce of truth, nor will they be able to make meaningful and critical choices when constructing that informed worldview. And I think applied to copyright, that again, that lends to the silence of how it lends to the silence of certain internet era forms of expression, and perhaps the truth that might be built into that. Secondly, I'd say I subscribe to sort of the self-determination theory of copyright. Again, the tenets of that are free expression is a necessary component of individual self-determination. Free expression is the means by which we form meaningful preferences and exposes us to competing options, and again allows us to articulate our own views. That's all good. And, in the aggregate, that means that, we as a culture are exposed to a variety of things and art forms, and, including fringe art forms that are not part of the mainstream. And basically, by having that perspective, we're actually meaningfully be able to participate in shaping culture. And so meaning making in cultural meaning making is decentralized and democratized in that way. And so kind of like taking these assumptions and saying like, yeah, that's a good thing, and copyright shut out that that meaning making, or it is kind of my grounding, my sort of MO going through this presentation. So keep that in mind. Okay, so I'm just going to go through a quick survey of fair use jurisprudence, kind of like what a mess it's kind of been. And there are so many cases out there that if you have any that kind of fit into this, please feel free to share with me. But these were the major ones that I've come across in my research. So, fair use jurisprudence, how it's applied in the laws how it's applied in the court has, generally headed in a liberal direction, but there still remains a sizable amount of uncertainty with regard to whether, especially with regard to whether internet era appropriative and adaptive uses of copyright qualifies transformative. And again, to this day, the Supreme Court has not weighed in on this question, whether, internet era works kind of are transformative. So maybe that'll happen in the next few years. I don't know. I definitely like to see what they say. But that means that there's a great deal of discretion in interpreting the fair use, fair use determinations that's left to the courts. And so this is one case in the Second Circuit in 1992, Rogers versus Coons, where the court said that basically a secondary work needed to be commenting on the original to be deemed a fair use. So I don't know if you see like kind of the comparison here. You've got the original photograph. So the photographer is named Art Rogers. He owned the copyright in the photograph called Puppies. And then there's a defendant sculptor, Jeff Koons, who is like a kind of a provocative appropriation artist, collage artist. He used a sculpture, or he created a sculpture called String of Puppies. And Koons claimed that the purpose of the resulting sculpture was to comment critically both on the original photo and the political and economic system that created it. So in his mind, he was commenting on the original copyrighted work. So probably trying to get it into the realm of fair use. He displayed the String of Puppies work at a gallery and sold, a lot of copies to collectors. So Rogers, the photographer, brought, an action for copyright infringement. And then, of course, Koons asserted that the copyright was fair use as a parody of the original. In this case, the Second Circuit held that Koons' sculpture did not qualify as a transformative parodic fair use. So just keep that in mind, like, this is not fair use. But in another case, SunTrust Bank versus Houghton Mifflin Co. This was from a 2003 11th Circuit case, where they kind of stretched the meaning of transformative, and in their holding, they held that the alleged infringement in question was a product fair use. So in this case, we have an author named Alice Randall. She argues that her novel, The Wind Done Gone, is a critique of Gone with the Wind's depiction of slavery and the Civil War era American South. And so to this end, she claimed that fair use specifically permits criticism and commentary of a copyrighted work, and that protected her novel. The court agreed with this, the 11th Circuit, because The Wind Done Gone, they, in their determination, was a parody of Gone with the Wind. And they explained that, like, for purposes of the fair use analysis, a work is treated as a parody if its aim is to comment upon or criticize a prior work by appropriating elements, in order to do so, and creating this like new artistic work as opposed to like a scholarly or journalistic work. And so this kind of highlights this like troubling distinction between parody and satire that was at least back then driving fair use jurisprudence. So, the purpose of a parody is to mimic another work in order to comment on or criticize it. And in doing so, a new work is created. One example that y'all might know about is, the Weird Al Yankovic song, let's say Smells Like Nirvana, is an example of a parody. And he makes a ton of fun of Nirvana. And, most copyright holders or most people don't like being made fun of. So it's more likely that the copyright owner won't grant a license, which is why, a parody will more likely be viewed favorably by a court in a fair use determination. So, parody targets and mimics the original work to make a point. Whereas on the flip side, a satire uses the original work to criticize something else entirely. And that's not generally protected, or it's not viewed favorably. But that's what's driving this is like so interesting. It's like the purpose, right? So on the one hand, it's like, just because, you're criticizing something. I don't know, the distinction between parody and satire, I think, is like really interesting and troubling. But the idea is that satire you need to justify using the copyrighted work because it's not dependent on copyright, whereas the parody is, in order to make the parody, you need to use the copyrighted work. Another case, in 2006, this is Blanche versus Coons. So Coons' controversial works again enter the judicial arena. So you can see here that Coons has constructed this like pictorial collage. This is the one on the right, using like various photographs that include a copyrighted photograph of that's owned by a photographer named Blanche. Blanche's photo portrays a woman's legs, reclining on a man's lap in an airplane cabin. Like that's the image. And then what Coons did is he collages it by recropping it and then reorienting the photo, then placing it among several other pairs of women's legs. And then so in the lawsuit, he claimed that the collaged pairs of legs were shown to represent the social and aesthetic consequences of mass media, whereas the purpose of Blanche's photograph was to illustrate metallic nail polish. And the Second Circuit agreed, saying that the Coons collage was transformative and that it offered new aesthetics, new insights, and new value to the original. However, I think that that value piece, like what creates value, what adds value, like new aesthetics, it's very subjective. And if you just go back to the first image, like I mean, yes, there's less work. I get less. There's maybe these images are more similar to each other than these, but I'm not seeing like it just seems like a very fuzzy line to draw. Another fun case here. So J.D. Salinger versus Colting. So he sued Colting to stop the publication of a book called 60 Years Later, Coming Through the Rye. So he alleged that it infringed his copyrights in the 1951 classic Catcher in the Rye, which maybe some of you have read in high school or something. Anyway, the federal court of New York, hearing this case, agreed and issued what's called a preliminary injunction. But all you need to know is that it banned the publication of Colting's book for the meantime. That then went up to the Second Circuit, and just kind of going over the facts real quick. The work in question, yes, it uses many of the same plot points and scenes as Catcher in the Rye. Similar to The Wind Done Gone, right? But in Colting, as stated in the case, said that like he meant for it to be a critical examination of the character Holden and the way he was portrayed in the original work. And then, of course, the relationship between Salinger, who is the author of the original work and is actually fictionalized in the new work, and how he deals with his iconic creation and of course, the life of Salinger as he grows old. So it's quite different. Salinger, on the other hand, said that this is like a derivative work as a sequel. So really interesting stuff. But if you take this literary fair use case and kind of apply it to the prior one that I covered, it's a, all I can say is that fair use jurisprudence is quite patchy. But the Second Circuit affirmed the lower court's preliminary injunction, stating that the work, in fact, was not transformative, even though, again, SunTrust kind of, we saw a similar recontextualization in that case. So, larger point is that this is inconsistent. Now, this case is one of my favorites. This is a Second Circuit case that took place in 2013, and it was, the court took a groundbreaking approach to fair use, and holding that a secondary use need not comment or critique the original to be transformative. So that's huge, right? So it doesn't need to comment on the original as long as it produces a new message. So I'm thinking about like memes for a second, right? Where it's like, you see there's a original image, and then there's like a deep fried meme, and it's just like, what is this? Is this satire or parody, or the meaning is not as clear as it has been in like earlier cases that I went through. And so, but I think that's still transformative. Of course, that's my opinion, but I think that's still it's interesting what these cases kind of bring to light. It's like what makes an artwork transformative versus derivative, where you want to still maintain a sense of protection for derivative works, because you want to be able to protect the artist's interest in expanding to a sort of like foreseeable market for their work. So in this case, the plaintiff and photographer named Carew, I don't know if I'm pronouncing it right, so hopefully I am. He published a book of portraits and landscapes, of landscape photos, titled "Yes, Rasta." Prince, on the other hand, another well-known, collage artist, altered a number of Carew's photographs and incorporated them into a series of paintings and collages called Canal Zone. And so, in its holding, the Second Circuit said that, look, the law actually doesn't impose any requirement that a work comments on the original, or that its author on the original in order to be considered transformative, and that a secondary work then may be constitute fair use, even if it serves some other purpose other than the traditional fair use purposes that I talked about earlier, like criticism, news reporting, teaching. And so I think that's very suited to these new forms of art that we're seeing through the proliferation of online platforms and things like that. So I think this case is awesome, and fair use should be kind of model itself with the Carew framework in mind. And so with that framework, that casts away this like reliance on the rigid satire parody distinction that we saw in SunTrust, and that the courts had been relying on. And then again, assuming that commentary is not necessary for a successful fair use defense, and what is considered transformative. Importantly, in this case, it was said that it's based on the reasonable perception of the new work. So reasonable perception of like the reasonable viewer. So it's an objective standard rather than like kind of the it being up to a court here or there, kind of deciding like what's a valid purpose, secondary purpose. This is like, well, this is grounded in what society thinks is like, yeah, this is transformative. And I think, if you replace this image with like one of the common memes that we see propagated throughout the internet, like I would say that, yeah, that's it. I would be surprised if there weren't a large chunk of society agreeing that like it is a transformative use and it deserves protection. So, and that, excuse me. So that kind of gets me back to the comparison, right? Like, to me, there's a parallel between these early fair use cases and then, of course, the memes that we see throughout the internet. Of course, this Carew case, that expansive interpretation was short-lived. There was a case called TCA Television Corp in 2016, where basically, I mean, I won't bore you with the details, but basically there was it called that that the interpretation of transformative, even though the facts of the case, really matched, if not more, the level of like transformation that had taken place. But it's a really cool place. You should look it up. It has to do with David and Costello, the comedy duo. But I think I'm running short for time, so I probably won't go into it. And so the takeaways here are that, look, like there is a significant degree of uncertainty in jurisprudence over fair use. But I still have hope. I think if we were to go with the sort of the conception of what's transformative from a like audience focused inquiry, then it would match, the outcomes would be more matched with what society deems as like culturally valuable in our journey to, create meaning, create meaning and interact with each other in like this cultural matrix. So again, it's tough, right? Like how transformative is transformative enough? And no one really knows until the appellate court sings, to quote another scholar on the topic. So taking like art forms such as remixes and mashups, it's hard to say whether it's a derivative work or transformative, but I think when you now consume that work, you'll kind of have this appreciation of, it really falls in this like interesting gray area. So these are kind of, I have like, from the outset, I think it's important to note that, the cost of infringement can be quite significant. A successful plaintiff can opt for, statutory damages if instead of actual damages, and that can range from like $750 at a minimum to $30,000 per work infringed. And then if that infringement is considered willful, that ceiling rises to $150,000. Of course, on the flip side, if it's demonstrably innocent infringement, the floor drops to 200. So just keep the money piece in mind. Like it's a lot of these artists are taking risks, and I think the whole idea is that if you're small enough, you kind of stay under the radar. But it's not uncommon to hear about rights holders like just picking that one person and making an example out of them. But some examples that I can think of, like especially with mashups, I don't know if y'all have heard of the DJ named Girl Talk. Really popular mashup DJ. I think around like 2010 was kind of like he was in his heyday. But he rose to fame simply by making danceable musical collages of like very short clips from other people's songs. So one of his albums features like 300 samples, and in the real world, and he's kind of stated that he didn't do this, but he'd have to get a license or a master license for each use. And it's worth noting that he has never been threatened by a lawsuit. However, and because I think probably the rights holders are worried that if it gets up to the Supreme Court or something like that, then it could set or an appellate court, it could set a bad precedence because they might rule in a certain way. So he hasn't been touched, but it's worth noting that iTunes and then both iTunes and then another prominent CD distributor stopped carrying one of his albums due to legal concerns. So there is that like, fear on the sort of the publisher and platform end where it's like, we're just not going to, we're not going to let you disseminate on the platform. Of course, with sampling, in legal terms, a musician who uses parts of another composition creates, again, what copyright law calls is a derivative work. So the permission of you have to get the permission of the original songwriter or the current copyright holder, and that's often the artists themselves if they're self-published or the label. And that can kind of be a hunt, not gonna lie. But hip hop artists who haven't, in the past gotten permission have been sued, often successfully. And that's the thing with like a genre like hip hop. That goes hand in hand with sampling, for better or for worse. And, we've seen samples that have become sort of the core element in some of the greatest records ever. In fact, I'm going to grab my phone and give you an example real quick. So I have enabled my phone to be able to transmit sound through this. So I'm just going to do this real quick for educational purposes. But okay, so you'll see. So there, the track, the album on the left is I'm about to play a track by English producer named Fortet, and it's a 20-minute song. So I'm not going to play the whole thing, obviously, but around throughout the whole song, he's sampling a classic by a very famous Indian singer named Lata Mangeshkar, and it's interesting because you'll see like, okay, so I don't know if can you hear? I can't tell if you can hear, but I'm gonna assume so. I'm hoping.
Yeah, we hear it.
Okay, perfect. Okay, so it's like an amalgamation of sound, right? And then you've got the original underlying work, which, all right, so around second 35 is that's the piece that Fortet samples and like overlaps and just, does a lot of interesting things to it. And I don't think they're really comparable anymore, Now, Fortet's big enough that I bet this was licensed. I'm not privy to that information, but, another popular example is like Jay-Z, for example, right? So in his song, Big Pimpin', he thought the sample that he incorporated was actually part of the public domain. But it turns out it was not, and so he had to acquire a license for $100,000, if I remember correctly. And then there was like a lawsuit that ensued over moral rights, which is outside of what I'm talking about. But that lasted like, gosh, maybe like 10 years or something. But I'm just gonna play, part of Jay-Z's song for a second, and you'll notice the flute part, right? Like that's the piece that he sampled. And I'm pretty sure everyone's fairly familiar with this song. And then you'll notice something familiar. So this is a song named Kosara by Abdel Halim Hafez, who's the Egyptian composer. And that's what he sampled in Big Pimpin'. And and it's interesting because, they kind of found out about it in a funny way. And, Abdel apparently rarely released a studio album because he was purely a live singer, or a live composer. So really interesting stuff. But that's the point here. It's like, what do we mean by originality here? I think at some point, especially with DJs, right? Perhaps it's different than producers, but with both actually, is that at some point it's like the DJ that is sought after, and it's their technique in mixing, for perhaps that's the primary focus than the underlying material. Now that's a personal view of mine. I don't know if that would like pass muster in sort of like what does society think about as transformative, but at least now you're exposed to that fringe non-mainstream view. So I think that's worth noting. Another interesting area is re-edits, right? So these are like different than a remix. So a remix will use the original stems of a track, and it's usually licensed to a producer that the artist wants to work with. And then a sample, as I showed you, is usually where an artist kind of completely recontextualizes a sound. And then, of course, edits, popular edits that I'm trying to think of an example, but there are people making re-edits of like old disco tunes and classics that are kind of bringing it, recontextualizing it for the dance floor. So it kind of breathes a second life into it, in my opinion. But you know, while these re-edits are you know, staples of the dance music culture, it's, you know, like the underlying material is the primary focus of the edit. They've kind of been regarded as you know, the black sheep of production practices, but I personally love re-edits and like retakes on things. I think it keeps things fresh. But you know, the question is that stealing? I think that is certainly, I'm unsure about that. Like, I'm on the fence, you know. But if recontextualizing is kind of like a meme, right? Like you're recontextualizing an old disco tune for, let's say, like you're making an edit for like maybe an old classical tune and you're making an edit for the dance floor. That's a different setting. It kind of could be, and maybe you can connect that to what a meme does. You know, but again, I think an edit is like an artist's vision, is sort of like revolutionizing the others, and then while maintaining the lineage and heritage of the original. So I think it's actually kind of like a bit of like a love letter to the original. Of course, you know, you should get a license if you can. So anyway, yeah, I think that's a really interesting area of law and art, and we'll see, you know, what happens when that goes through the fair use test at some point. So licensing, I'm a bit short on time, so I'm gonna again zip through this, but licensing is a whole different beast. You know, with sampling, like I said, you have to clear every sample you use in a song, and you need a master license. And because of the complexity of master licenses, you might have to make your request to the rights holder like months ahead of a release, while also having a, you know, backup plan in case the request is denied. So like, for example, in the case Bridgeport Music versus Dimension Films, NWA used a 2-second guitar chord from Funkadelic song, Get Off Your Ass and Jam. And the sample is just 2 seconds. It's lower in pitch, and it was looped 5 times in the song, all done without Funkadelic's permission. And the Sixth Circuit ruled in Funkadelic's favor, and also, you know, eliminating the de minimis standard in copyright law, which was basically dismissal of copyright infringement claims if like the use, like the sample was just like insignificant. But you know, that's worth noting. Like, if there's a whole genre of music that depends on sampling, like hip hop and you know, electronic music. So it's really interesting because it goes so counter to the ways that we're finding ourselves communicating information, where we are taking bits of media and like smashing them together to make these like sort of beautiful structures that we share, you know, online with each other. If you want to, other license woe is that if you want to publicly perform, you need a public performance license, and then you know, you need to clear, you need to contact the rights clearing orgs such as ASCAP, TSAC, BMI if you're in the US. And it's kind of hard to, I mean, I was struggling with this because, I mean, hopefully I have time to do the mini set, but I was struggling to find like which songs are, you know, like how to find where, like who the rights holder is. So that kind of took some interesting, you know, that took me down a weird, interesting journey. And then of course it gets harder with like obscure media, and then, you know, independent record labels. And then of course, if the music is like self-published, then of course you need a digital audit. If you want to transmit over a digital audio, you need a, like, there's a statutory license scheme. And so that's all to contrast, right? Like there's so much time and research that you put into it to make like one track. Is, you know, you contrast that with the statement that, you know, Daniel Ek, this, I think I pronounced that right, the you know, CEO of Spotify has said, you know, stating in a, I think in an NPR interview with Ari Shapiro, he says that, you know, musicians in the age of streaming cannot record music once every 3 to 4 years. And like right back then, like you'd record, this would be the whole process. he said that's not going to be enough because of streaming. And so it's like, well, okay, if you're telling musicians that they have to keep on like perpetually creating content frequently, then that, if you're like a producer that relies on sampling, like that's your style, then I mean, does that just mean you're out of luck? So, you know, I think the platforms kind of make it essential, like the amount you have to you know, put out is really makes it hard to actually find the license and, you know, get the right clearances. So, okay, I'm going to just zip through this again. So I find it very interesting that a lot of online platforms, you know, they uh, they rely on user generated content, yet in all of their terms, uh, you're basically representing and warranting that you are not transmitting any copyrighted material or any unlicensed material. So if you just like look at some of this language, you know, I won't bore you through it. I guess it's kind of, you know, unless there's some lawyers in the audience that you might find this interesting. I am planning on making a sort of a terms comparison for all the online platforms, specifically for, you know, DJs and producers and whatnot. So if you're interested in that, you know, please let me know. I'm still working on it, so that's a, you know, work in progress, and it won't happen. That it'll take some time. But yeah, I mean, just think about the typical, you know, typical DJ on Twitch. They're uploading their mixes onto their account or in, you know, an independent internet radio. And I, you know, is every song cleared beforehand? I seriously doubt it. And then of course, you know, in Twitch, there's a one-way indemnification, which, you know, I guess you can look at if you're interested, you know, you can find out what indemnification is, but basically you'd have to indemnify Twitch against any claims arising out of your content that you put on, if that content violates the rights of a third party. So that includes copyright. So you can get, you know, in pretty sticky trouble per these terms. You know, Facebook is interesting. I had a hard time like making sense of their terms because everything is like baked into links. Kind of is on brand, I suppose. But you know, Twitch and Facebook are popular live streaming platforms that a lot of, you know, DJs that are now out of work and they have to somehow connect their audience. They're using those platforms, and so you know, maybe to their detriment. All right. So a little update with Facebook, and some of you might have already heard about this, is that, you know, in starting October 1st, Facebook has stated that users won't be permitted to host what's called music listening experiences on the platform. And so like they kind of added some color to it. So like music in stories and traditional live music performances. So if you're like filming a band or artist, like that's permitted. And like the shorter the clip, the better. But there always has to be like a visual component to the video. Otherwise it's considered like a musical listening experience. So the idea is that the recorded audio should not be the primary purpose. So, I mean, if you're a DJ, and, you know, every Friday during peak quarantine, I was like streaming into Facebook Live to listen to, you know, every Friday they have a London Disco Society has like a 2-hour stream. You know, per these terms, like I don't think they'd be able to do that anymore because it's primarily a listening experience. And so the issue is that, you know, artists that perform music outside their own discography, which frankly is like a lot of musicians, they're impacted, and DJs are basically out of luck. Again, YouTube, you know, same thing. So yeah, it's kind of it's really interesting to see all the different terms with the platforms that rely on user generated content. And, you know, it's kind of like content that in reality can't be cleared for every cleared from like a IP perspective. Yeah. So yeah, I mean, SoundCloud is like somewhere where I see a lot of like pre-recorded sets. Lots of like internet radio stations put their mixes on there. So SoundCloud in particular has a lot of language on, trying to say like, do not upload third-party content, that you're not licensed to upload. So you can get in trouble. Mixcloud is an interesting platform. It's quite mission driven. Basically what it is that, if you want to, it's a bit more of a balance between like the person that's uploading the mixes, but also, being able to credit the content, the underlying content in that mix. So basically when you upload a mix, you provide certain information about the music and on the tracks, and there are certain restrictions. And like, for example, I think you can't put like 3 songs from the same album or something like that. So it truly has to be like a mix. So it's made for like tastemakers and curators and DJs, but then also respecting the original artist. So I like that idea. I think it's cool. Yep. Again, this is kind of a more screenshots from the site itself. These are the restrictions, like I said, no more than 3 songs from an album, no more than 4 songs from a recording, 1 recording artist, etc. So yeah, it's really interesting. We rely on these platforms so much, and I think it's interesting to know, maybe some of you already have heard about this key piece of legislation called the DMCA, which is the Digital Millennium Copyright Act. That was an effort to modernize the Copyright Act, and in that there is a safe harbor for online platforms. You might be wondering, like, how do they get away with it, right? Like they know that there's user-generated content and there's a lot of it. But the idea is that like we don't want to chill the development of these platforms, right? So there's a safe harbor in that law that basically acknowledges that like platforms can't monitor each piece of user generated content coming through, but they have to address any claims of like IP infringement. So there's like a takedown notice mechanism, and so that, and they can be fined if they don't comply with those takedown notices and that kind of mechanism. So there's still a fear of like litigation and fines that drive platforms like SoundCloud and YouTube especially to maybe over censor contested content via their DMCA takedown procedures, oftentimes in lieu of actually investigating the merits of the request. So that's a whole different interesting area of law worth looking into. But the takedown regime is kind of a mess. So my recommendations are, first of all, focusing on fair use as a way to as a way to reunite copyright and freedom of expression. The First Amendment, like how that to reunite them in a way that they are furthering the same original goal, and that is protecting and maximizing the cultural availability of art and science to the culture at large. And so if we have the Carreau version of transformative, right, where it's like it's not so purpose specific, rather it's just aligning fair use with like the broader cultural norms of what is transformative. So having it be more audience focused, I think that would that would actually bring fair use into that would make it more of a useful mechanism in measuring, like, okay, where are we as a society that we consider this infringing and this to be a valid form of art, where we want it to be captured by fair use. So we want it to be a mechanism that evolves with time and technology. Now, and then the second piece of that, and I can go into this more, but I'm definitely low on time, is that we'd switch the burden of proof to the rights holder as opposed to the infringer. So whoever is actually claiming that copyright infringement took place, the burden of proof should be on them. Currently, it's on the fair user to prove that their use is indeed a fair use and not copyright infringement. But the issue is that fair use is so fact intensive, and there's a lot of uncertainty. So the odds are stacked against the fair user just from the outset. And then I would say, lastly, worth looking into is that there are alternative licensing schemes. I wish it were more ubiquitous, but basically Creative Commons licensing allows rights holders to basically choose a degree of exclusivity they want with respect to their work. So they can kind of mark like, okay, you can make derivative works of my song, but it can't be for commercial uses. So like there's ways to, kind of toggle the between the preferences, and I think that would help disseminate, just have information be more available so that you're not outright infringing just by using like a 2-second sample, or that if you want to use 5 samples, you're not having to go down this like goose chase of figuring out like how to get the appropriate licenses. That's it for me. If you have any questions, follow-up questions, feel free to, I've got the email right there. If you want to request that analysis I was talking about, feel free to, request that. I'll take note of it. And then if you just have song recommendations, go ahead and send me a track or something. But that's it for me. I know we have 20 minutes left. Kevin, what do you think? Should we do a Q&A?
Yeah, I think
and then if people want to stick around later, I can do the set? Or
yeah, I think we should always do a brief one because there were quite a few questions asked in the chat.
Oh, really?
Some of them pretty interesting. So I think we'd like to hear some of them. And I guess, you talk about song recommendations, given everything you're talking about, but based also on a link I shared in the chat. I trust you've heard DJ Shadow's Introducing.
I don't think I have, actually.
You should check that out. It's 1996, a San Francisco DJ hip-hop artist who he made an album in 96 that was pretty much nothing but samples and remixes. There is no original music on the album. It is nothing but a collage remix of other stuff.
Oh, you know what? I think I actually came across, I haven't read it. I haven't listened to it, but I read about it. Very interesting.
You should check it out. It's very good. And frankly, it's kind of miraculous he didn't get sued into oblivion because, he sampled Metallica on the album.
Yeah, who are known to be very litigious.
Mm-hmm.
Okay. Wow, there's a lot of questions. Okay.
We only have a little time. Maybe pick what you think are the most interesting or best ones, and then we can try to wrap up, and you can play us a little bit of your set, and then people can whenever they feel like it.
Awesome. Perfect. Someone says they feel attacked by the Coldplay comment. Sorry about that. All right. Oh my gosh. Well, Kevin, did anything pop out to you? Because I'm just scrolling through these questions at the moment.
What's one that I would want you to see? Well, somebody recently asked specifically, what is the Fifth Circuit's legal track record on these intellectual property issues? Are there any nuances to the way Texas is ruling on these things versus other areas?
That's a good question. I only really focused on Second Circuit cases because there's just so much entertainment flooding into that. I haven't read I'm not really sure what the Fifth Circuit stance is, but I imagine it's not. I imagine it would be more on the conservative side anyway, especially if we're talking about what's considered transformative. You saw even in the Second Circuit, they would flip back and forth. So I imagine that, just to avoid sort of a circuit split in that sense, they would probably just align with sort of the circuits that are comment on this more and have more cases. So, what is it? The Second Circuit, and then and the Ninth Circuit, which captures California, I believe.
I think the Ninth Circuit is California. Yeah. Yes, I believe.
Yeah.
I am not a lawyer, so everybody listen to Ritika on law stuff. I'll stand by the software stuff, but take law things I say with a grain of salt. We had a question about your thoughts on just Creative Commons licenses and
Mhm.
the strengths and weaknesses of them. I think just somebody wanted maybe going a little more into your thoughts on where Creative Commons solves these problems and where it doesn't.
Yeah, absolutely. So the issue with Creative Commons is that it hasn't been tested out in the courts yet, right? So there's that issue. But I think it's a really great start because it's not sort of outright assuming that like you you know you don't have to go through the licensing nonsense of like um giving out the right to for someone to create a derivative work, or like for someone to use it for a non-commercial purpose. At least at the outset you can kind of you can make those settings, and then it's available on a platform. The Commons licenses are also machine readable. I don't really know much more about the tech piece, but I know that it's it's like nicely embeddable with a piece of content that's online. So if you go to like, if you've gone to like Creative Commons, the database, you search for a term and you'll see like, it's a very good like UX or UI. I honestly don't know the difference, but it tells you immediately like you need to attribute the author. But if you can use it in a derivative way, but as long as there's attribution. And so I don't know if you noticed in the EFF meetup invite or on Facebook, one of the images is a Creative Commons image that I found. But to stay true to the spirit of Creative Commons, I had Kevin attribute the author. So
Yeah,
great.
I'm not always the best at attributing images I use on the internet, so I appreciated Ritika saying, "Yeah, we're talking about this. Actually, credit it." And I'm like, "Yes, we'll do that."
But I think it's better than the current copyright regime. I think it's there's probably room for improvement. It hasn't been tested out, but I think and there would be kinks to it once it's ubiquitous, or once if it ever became ubiquitous. But for now, it's really just limited to like Wikimedia images, and then Wikipedia and Creative Commons, their database and whatnot. But I really like that Wikimedia uses Creative Commons imagery. I think that's great.
Let's see. Another interesting question that just got asked. Somebody was basically asking about the distinctions between live streaming copyrighted content versus then playing back that live stream later with the copyrighted content in
Mm-hmm.
it. Like, is the law different as far as the legal distinction of these two scenarios?
So if you're live streaming, I have heard anecdotally that Facebook's getting better at real time, just like muting your set. I think they've gotten really good at it. With Twitch, I know that like if you upload a set and it's like video on demand for, they used to do it where it would just like stay on for 2 weeks. I don't know what the current state of like the VOD is on Twitch, but I know that like I've been told that my friends that will stream the live stream and then it's recorded and then like stored on Twitch, they will retroactively mute the parts that have been identified by their like I don't know if they use content ID technology, but they use some sort of scanning technology that they'll go in and just mute it.
And is there, and I know this is one of the big debates around systems like Content ID in general, but I think as anybody who has had to fight with Content ID flagging their stuff and feeling like, no, this is covered by fair use, there's not really a good process to appeal to a human being right now from what I've seen. Do you think obviously I get why they use those systems because there's no way to moderate at scale on these platforms. Do you have thoughts on how maybe this moderation can happen without so many false positives where people have their legitimate content removed and there's nothing they can do to appeal or get it back?
I don't know, because
I mean, there have
like,
even been cases of like people didn't like a YouTuber and they reported them for copyright infringement, even though they hadn't infringed copyright. YouTube took it down, and this has actually been a tactic some people have used to chill speech they don't like, actually.
right. Yeah, I know with YouTube, they've been recently, I mean, not recently, they've been put under fire for a while. That, there's this uncertainty that comes out of the DMCA notice takedown system. And so there's a tendency to over censor, and just like, if there's even a question, just take it down. And then, yes, I have heard that then the appeals process with the platform is pretty arduous. And um, I know that like in the law, it says that you're supposed to, when making a takedown request, you can't it can't be like frivolous, and you're kind of like representing that you do own the copyright to the work in question, and that you have to that you have an obligation to consider the fair use piece of it. But I mean, that's kind of just, it's hard to enforce. But yeah, people will have a really hard time getting their content back on. And like a lot of streamers that, or a lot of YouTubers that make, they've lost like hundreds of thousands of dollars because of like a takedown of their video, because it featured like in the background like 4 seconds of a copyrighted song. So that's to me, I don't like that when it's like in the background, like, the famous baby case, or there was a baby dancing and there was like a song in the background. That kind of led to a lot of sort of a litigation nightmare. But I think that system's kind of, it's a mess. I have no idea how one could fix it. I guess I know YouTube has like an allow list. So if you want to put copyrighted content in your videos, you have to be on that artist's, like the creator's allow list. But that's kind of like the whole licensing thing again, where you're having to hunt down. It's just very labor intensive, and that doesn't really match the ease at which you can share information on these platforms. And the platforms are just like, we have no control over what what is in the user generated content. We just have in the terms that you say you won't, but like, we all know that, that's not the reality.
Right. And let's see, another question we had here. We talked about the distinction with, copywritings of sound artistic things, that there's a distinction between the composition and a
Mm-hmm.
particular embodiment of the composition in some way, as far as copyright. Somebody asked, are there similar distinctions for visual works of art? Is there a copyright for the idea of the visual work of art distinct from a particular version of that? Or is this a quirk unique to auditory artistic expression?
I think it's mostly a quirk with the audio piece, because there's the musical composition, or the musical, that part is like the lyrics and the composition, and then the sound recording is like the actual recording of the whole piece. With a visual, with respect to what the person's asking about, like whether you can copyright like the idea of a visual work, you can't copyright ideas, right? Like that kind of falls into the idea expression distinction, where if it's like like, I guess with visual is kind of tough to separate, but you can't copyright ideas basically. And I'm trying to figure out an example in which that would apply to a visual work. So it's like, if I took a photograph of something, I have a copyright in that photo, but I can't foreclose people from photographing trees or something. Maybe that's the like idea versus expression distinction. Like maybe I'm a photographer that I specialize in like tree photography, and I have a particular style. What a weird example. But I can't stop someone else from becoming a tree photographer, but I can stop them from emulating my style, perhaps, if it's like super unique style. And yeah,
Right.
TikTok's really interesting because it's like a way for people to communicate. You have like duet upon duet upon duet, and then there might just be like bits and pieces of media that's like mixed in, and that I'm sure that IP, like the layering of all the IP, is very messy.
Let's see. I think I've mostly gotten to the questions you asked. There was one more I asked, and I don't know if this is something you could comment or not, but I think somebody asked if you were at all familiar with the legal controversy around the Eyes on the Prize civil rights documentary, and how for many years it was not viewable despite being considered by many an important part of the public conversation on civil rights in this country because of a nasty fight over who owned the copyright of the documentary.
Oh, that's fascinating. No, I don't. That kind of rings a bell.
It actually was.
I am entirely that is all based on me learning about it just now, reading the Wikipedia page. So,
no, that's really interesting.
Hoping that maybe you knew more.
No, I mean, my only comment is like, so was it embroiled in a copyright dispute, and because of that, maybe there was like an injunction?
I've just been told it was about the music rights specifically, about the music played during the documentary, and that the fight over this meant that the entire documentary was not viewable by anyone, not just the it without the music.
Oh wow!
And I mean that is interesting that I hear it's about the music, because I know this seems to happen a fair amount, that there'll be like old TV shows where like 1 or 2 episodes of the show are missing from syndication and you can't easily see them. And I swear half the time it's because they used a popular song and they didn't have the permission to ever replay the song again.
Could you restate that?
Sorry. I'm just saying that it seems that it seems that like, I guess then if I had a question, it'd be, how does copyright work as far as when different mediums are sort of coupled together? Like if there's a problem with a work because the music's copyrighted, can you rebroadcast or share the documentary if you strip the music out? Or is it like, no, now the whole work is...
I think in theory you could. I just don't know if there's technology. I mean, I guess you could strip it out. I mean, I think that would be the initial request, right? It's like, well, nothing, once you strip it out, there's nothing stopping you from releasing it.
Right. And I think, and I'm saying a few more details in chat, specifically it was that they had the rights to air it with the music, but then they didn't have rights to put it out on video with the music.
Oh, that's fascinating. So I mean, I guess presumably then, was it just like a issue of like video on demand versus like a live,
Here's a quote has just been provided by one of our participants. Many of these licenses expired by 1995, and the film's production company Blackside could not afford the exorbitant costs of renewing them.
Oh.
So they had the copyrights, but by the time they wanted to release it on home video, they didn't have the copyright to the music anymore.
That makes sense. So then if like the terms of the license, I mean, if the terms of the license dictate, so yeah, I mean, I don't think the optics look really, they aren't favorable, right? Like you're stopping a civil rights documentary from airing in, I imagine, a pertinent time. So that's not good. And, I think if I were the copyright holder, I'd probably like take that into account instead of like chasing down the license. But at the same time, the terms of the license dictate. So
yeah, that's an interesting edge case. I can see it both ways. I mean, is there, in current copyright law or in reforms you'd want to see to it, do you think there's a point at which something could be argued to be of such benefit to the public that it could invalidate somebody's copyright?
I don't think that.
I mean, I'm just curious. I don't even know what I myself think on it. I'm just think it's an interesting question.
Yeah, I wonder. I mean, I think like. Well,
somebody just said, yeah, eminent domain for copyright.
Nice, good, Scott. He's Full of singers. He's my roommate.
Oh, okay. It's an interesting idea. I don't even know if it strikes me as something like that somebody would have thought of making a thing, but I have no idea if that is a thing or not.
Yeah, neither do I. Food for thought, though. I mean, if anyone wants to send me a link to that documentary, like via email or I see a lot of familiar faces here. If you want to text me, that'd be awesome. I've just been watching reruns of Sister Sister, so I think I need some more, maybe a little more intellectually stimulating content. That seems like really interesting.
Agreed.
Yeah.
Do we have any final questions before we wrap up the question portion and turn over to the social music portion?
I have a question.
Oh, David,
really
you are
quick.
here. Yes.
Yes. So this is regarding tools and So how do I word this? What kind of possibilities do you see regarding app developers or tool developers saying that they own some kind of a stake in or some kind of profit regarding what a user may have created using their tools? So if someone made a song in Ableton, you know, do you see any kind of possibilities of Ableton saying, okay, well, you owe us this much money because you used our tool to make this product?
I don't think so. Let's think about, let's say Microsoft Word, right? Let's say I draft up a short story. I can't imagine a world in which the tools, the company that is providing the tools for me to create this work would come in and kind of demand a portion of whatever revenue you get from that or benefit you get from that work. I mean, yeah, I can't imagine that happening with Ableton ever. With with app developers, that's pretty interesting. Where it's if you used someone's app to make something else. I'm not really sure, but I think when it comes to technology stacking, there's a lot of agreements in place where it's if you're using a sub-processor or a very different technology and that's an integral part of whatever you're creating, then there's definitely a deal that has taken place. That's more on the sort of B2B side rather than a user versus using a tool to make something. Does that make sense?
Yes, it does.
Cool.
I'll just say I was curious, so I started trying to do a little bit of Googling to the question of, can copyright be invalidated for reasons, and what's really interesting, the internet has nothing to say on this. not even a speculative paper of some law student somewhere thinking about it or some lawyer. And so I'm maybe this is actually less explored than I realize. Interesting.
Yeah.
Anywho, any final questions before we all can leave whenever we want and hang out as long as we want? Because it's our Zoom room. Nobody can kick us out.
Yeah.
All right. Well, I just, for those of you that we may be about to lose, I want to thank all of you for coming. I think this actually was our best attended virtual Zoom yet. So going strong in COVID world. So thank you all for keeping us relevant and interesting. And of course, I want to thank Ritika. This is the second time she has presented to EFF Austin, and both times have been quite interesting. And I hope we can keep hearing more from you, especially because the more regular speakers I have, the easier my life is as well. But this was great. Thank you so much.
Thank you for the platform. It was awesome.
And so, everybody feel free to stick around if you just want to hang out and chat as best as is possible here or listen to Ritika's set. This is an experiment, so if we have tech problems with it, apologies. We'll probably do this again sometime, but you may be witness to the initial technical difficulties if there are any.
Yeah, I'm new to streaming. This is my first time trying to set it up. I got the sound box and stuff, so let's just I'll give it a whirl. So just bear with me for a few minutes. But yeah, feel free to stick around or drop off. But yeah, I'm just going to go ahead and make some slight configurations.
I'm going to have a bourbon as if I were at the firehouse.
I
Unfortunately,
got a beer waiting for me, so yeah, I'm gonna do the
unfortunately,
same.
I don't have a door that slides sideways like that, but I can just pretend.
Amazing. Okay, let's see. Okay, so this is my setup. Let's see if I can. All right.
Are we allowed to dance?
I mean, my attitude is as long as you don't do something that could get us sued on camera, you can do anything you want.
Yeah, I can just go off camera.
Yeah, right. I mean, whatever you do off camera, I don't care. It's your house. But on camera, I'm like, I might not personally care, but please try not to do anything illegal on camera, especially because, remember, we're recording this, so there will be evidence later if you choose to do so.
I'm a long ways away.
Indeed. They'll never find you.
Oh, Kevin, while we're waiting, it's interesting because I've been very involved in the protests here as a legal observer and helping with the medics.
Right.
And the idea of operational security is really important and becoming more important. So we're using things like Signal and Telegram.
That's good. I'm glad you're pushing that in the activist community there, because I often continue to be rather amazed by how many really in the trenches activists don't seem to take digital security as seriously as they should or make it a priority.
Well, we actually, I'm not the expert. I do know some stuff, but one of the medics is actually in InfoSec. He works for a company that does
right.
Encryption technologies and things like that. Yeah, VeraCrypt is really cool. Oh, it's awesome because I have an EFF crowd. One of the things you can do with VeraCrypt, which is a derivative of TrueCrypt.
Right.
You can actually create, if you are going to encrypt an entire disk, a volume, be it a disk or a USB flash, you can create a partition of whatever type you like. I'm on Linux, so I had an X3 or X4, but if it's Windows, the NTS or NTFS, and put stuff on that and make a hidden volume within it. And so you put a password on the outer volume, and then you put completely different password on the inner volume. So what happens is if law enforcement compels you to produce a key, you can produce the key and it opens the outer volume, which you put stuff on there that looks suspicious but isn't illegal or whatever. It's not sensitive, and it's completely deniable.
A decoy encrypted file. Nice.
Exactly. And it's completely deniable. They can't even know that it's there. So they can't get any sort of court order to compel anything.
Interesting.
Yeah, I thought it was pretty impressive.
Yeah. Well, I mean, definitely, it's always good to educate activists on the techniques available to them. Because, I mean, yeah, at least here in Austin, I've reached out a lot. And actually, yes, we may be having mic issues with Ritika, so I'm going to shut up so we can actually see if we can hear the set.
Yeah, we can get some music, yeah.
While we're waiting on the 10 OW, I'll just say, wow, that was really great, Ritika. I look forward to a set of yours at Sahara Lounge whenever the world is back to normal. Yeah, no, I can't hear anything right now either. You know, we're figuring it out, but it sounds really great when it's working. Yeah, I'll just say it all sounded really good, Ritika, and I think we all want to hear more of it. And I'm sure we will figure out the technical growth pains. John even suggested that maybe Scoop could help you figure out a better way to wire it into the live stream, because he's been having to do a lot of that for Plutopia. So we'll iterate on this, because I definitely want to hear more, because the music's really good.
Also, whoop, am my mic on? Yeah, also no worries. I'm sure we've all had public demos go awry, so we feel you.
I mean, no comment. I mean, I've thrown EFF-Austin parties. They went completely smoothly. Nothing was exploding around me as the party was happening. That never happened.
This has even happened to Steve Jobs.
Or Elon Musk. I don't know who told him smashing in that window was a good idea.
I totally forgot about that. Couldn't have happened to a better guy.
Okay. Hey guys, can you hear me? That was a very interesting experiment setting up. My gosh, like live stream there's so many parts, you get distracted. So I
Well, when
you.
everything was working in conjunction, it sounded great. I mean,
Yeah.
no joke. I felt like I was like at Sahara Lounge or something. I know you were a big fan of that place.
Oh my gosh. Oh yeah, I love that
By the
place.
time we have a birthday, I'll sing happy birthday. I actually do that. I've been doing that since the beginning of the pandemic. Sending videos to people whose birthdays are singing happy birthday. And plus it's public domain now.
Oh, you saw my comment about happy birthday. I see. Yes.
Yeah, did you see my comment? They actually decided they invalidated the copyright.
Oh, they did. Lovely.
Yeah.
Yeah, that's kind of a silly thing to be copyrighted. It really is.
Yeah, I think it was I forget who owned it, but oh, I can look right here. It's the internet. But it went to a federal court. Warner, Time Warner owned it, and in 2006, a federal court invalidated the copyright.
Mm.
I was wondering about it. It was funny because you mentioned that, and I had done the same thing. Like, oh, this is really interesting talk. Oh, this makes me think of this or that, and was googling along. Yeah, well, you're trying to fix things there. Your talk was amazing. I really enjoyed it.
Oh, thank you. I appreciate that.
And yeah, I met you. It's funny. Like I've been involved in EFF-Austin, but I moved back to Buffalo. But I'm so involved in EFF-Austin that I come to these things. And I met you. I think I met you a couple times. In particular, the one where there was a individual from EFF in town, and we hung out at the patio.
Yes, the lawyer. What's his name? I'm being horrible. I know it was in February this year.
Alan Green, right?
Yeah, I think so. Yes.
Yeah.
Yeah, that was man, that was only in February. God,
I
this is
know.
the third year.
That was really this year.
Yeah.
Yeah,
Well,
that's
and
funny, 'cause, like,
yeah, I
I
mean,
lived in Austin then.
well, that's right. And well, yeah, and George is now up in Buffalo trying to kind of get an EFA chapter going up there. So, yeah.
Oh, cool.
Yeah, I
Very
don't think it's-
cool.
Well, we've actually germinated a few things because another one of our former speakers that used to live in Austin, Ethan, with Truth and Transparency Foundation, he's now trying to get a chapter going kind of in the Oakland area. Admittedly, the Bay Area already has a lot of chapters, but there's Oakland Privacy. No, it's not Oakland. Has Oakland Privacy. He's trying to get one going in San Jose, which doesn't really have its own one the way Oakland or Berkeley or San Fran do. So we've germinated at least 2 potential new EFA chapters.
Yeah, I want to give you a shout out, Kevin, because I had been thinking about it before I left Buffalo for Austin in 17, and after seeing how really what you were putting together in Austin, it made me go like, wow, I can do something similar. I don't think it'd be as good because my pool of people to speak will be small.
If you knew the amount of self-loathing and self-criticalness that goes into my work with EFF-Austin, you don't want to hear my internal monologues about running this thing. You really
man, you do such a great job. Your speakers, I mean, without fail, you have interesting speakers.
I mean, that's just I have cool
credit.
friends who know cool friends. That's them. That's not really me. I mean,
Runs a tight ship.
I try.
You do a good job.
Well, thank you. We're very happy to have you on the board, Ritika. You keep giving us great talks, and I think we're very lucky to have our staple of lawyers to you and Alex to shut me up when I get into like pure speculation, and it's like, yes, I know that sounds fun in a cyberpunk novel, Kevin, but that's not how the law works.
It's funny. I've been treading some lines lately in my activities with the protests here in Buffalo, because I'm in a signal chat with a bunch of the medics.
Right.
And I've been doing, some help with them, but I'm also in a chat with the legal observers that the National Lawyers Guild does. And there's, I'm restricted by that. They're like when I have the hat on. Oh, hold on. Oh, where's my hat? It's usually up on my speaker there, and I can just put my head up there. But we wear bright green hats to identify ourselves as legal observers. And when I'm doing that, the things I witness I can't even really talk about because I'm acting on behalf a lawyer and it's an attorney work product. So I have to think about that more than I usually do.
I mean, I know the feeling about having to be mum about everything you do. Like, I mean, my day job, I can't really talk about like half of what we're working on doing right now. I'll just sort of say we're involved in some very big, very heavy shit. And I wish I could sort of talk about it, but I'm not at liberty to talk about any of it. So I hear you.
Well, it's interesting because last Friday we had there was a march where it was in a close by suburb, and there's a group forming here called the Watchmen, who are a bunch of racists.
Wait, are they named after the comic book, which is making fun of racists?
No,
That's
no,
some silly irony.
Nor are they named after there's a group in, I think, Georgia or somewhere called the Watchmen, that were put on the
Hey, Kevin, got to jump in. I actually I have an 8 a.m. meeting tomorrow, so I'm like,
yeah, and actually the truth is I probably need to jet here soon as well because I have life, and my life until the election is done is going to be nuts.
yeah, get your popcorn ready. It's going to be a wild ride.
Oh yeah, it's not like things are going to be calm after the election. It'll whatever happens, it's going to be interesting.
Maybe it'll be our just like the last election, it will be the most like historically the highest attended EFF. Maybe it'll break another record.
I know, like, I feel almost guilty of like, oh yeah, the continued disillusion of the country is good for the brand. It's good for business. No, I mean, frankly, I would love it if everything fixed itself and there was no need for this. But whoever wins the election, I don't think we need to worry about that. I mean, I'm not here to try to play both sides of the sameism because they're not. But it's like, I mean, Biden literally launched his campaign with a big fundraiser at the president of Comcast house. I don't expect good internet law whoever wins.
If you want some political interestingness that makes you feel better about stuff, Vermin Supreme has been live streaming quite often. Are you familiar with Vermin Supreme?
I know who he is. Yeah. No, I mean, he keeps libertarians fun because he doesn't take it too seriously.
Well, his live streams lately will be just him walking in the
country. All right, Ritika, I'll see you.
Yeah.
Thank you so much. Thank you so much for the talk. Yeah. And we want more DJing. So yeah, we're gonna figure that stuff out because
I'll try to get the tech thing better situated for next time because that was so like another layer. So that was like a good exercise.
I definitely want it, if we have our virtual holiday thing, I definitely want it for that. And frankly, if once you get it figured out, if any monthly meetup you feel like simulating the hanging out at the bar portion on any of them and want to play music, you always
can do that.
You always have an open invitation on any meetup.
Yeah, I would like that. It's hard to go from like the presentation headspace then to the DJ headspace. So I was like, whoa. But whenever I will, if you guys want to just hang out after the next talk or the next talk or whenever.
All right. Well, John's one will be in November, so we can chat more about that. All right. Thank you so much, Ritika.
All right. Bye, all. Good night.
Bye. Night. Yeah, and actually, George, I probably do need to jet myself. So let's continue this conversation on Signal.
Sounds good.
All right. Thank you, everybody, for coming. Have a good night.
Take care.